SJC-11565 and SJC-11491. Anita Singh v. Scott Capuano.
Yes, counsel. Good morning.
Morning. Chief Justice, Associate Justices, may it please the court, my name is Michael Licker, and I'm here with my colleague, Kevin Conroy. We're from Foley Hoag, and we represent the plaintiff and appellant, Anita Singh. It took 5 contested hearings inside of a year in this case for Ms. Singh to get a fair hearing in the district court. This never should have happened, and it should never happen again in this Commonwealth.
Who was the judge finally that gave the 3-year order?
The judge, it was Judge Yee, I believe is his name, in Somerville.
Right.
The errors that occurred here are the types of errors that are both capable of repetition and likely to escape judicial review. And I think the facts of this case will help to demonstrate why that is the case. In February of last year, we went to the district court for what was supposed to be a 10-day renewal hearing of the restraining order. The district court refused to hold the hearing and extended the order for just 6 weeks and directed the parties to probate court.
Well, what was the reason for directing the parties to probate court, by the way?
The judge asked at the time there was a no contact order also for the plaintiff's minor child, plaintiff's and the defendant's minor child. The judge recognized that and asked the parties why they hadn't gone to probate court and suggested and then wrote on the order that they should go to probate court.
Okay, so that was February, what, 14th?
That was on the initial hearing was February 14th. That was on February 22nd, I believe was the date.
So the ex parte order was issued February 14th through the 22nd. On the 22nd, the order remained in effect, but the hearing was continued for 6 weeks to
the beginning of April.
Okay, and did your client go to probate court?
The defendant actually filed in probate court, so they did subsequently go to probate court. They went to probate court for the first time just before the April hearing in the case. So then in April, they went back to the district court shortly after the probate hearing, and the district court judge again declined to hold a hearing, refused to hold a hearing, but this time vacated 2 provisions of the restraining order without hearing any evidence. And those were 2 of the most important provisions, the no contact and stay away provisions.
And why did he do that?
He did that primarily based on the fact of the ongoing probate litigation. Specifically, he believed that an order of a visitation order of the probate court that had entered conflicted with a no contact and stay away order.
Did it?
I don't believe it did, and there's a few reasons why. One is that the visitation order had specific provisions in it about the times and places for drop-offs and visitation drop-offs. So there's really no reason for the parties to contact each other. Additionally,
had she moved to New Jersey at that point?
she fled to New Jersey immediately after getting the ex parte order. Yes. Just to go back to Justice Cordy's question, the other reason why is that the probate court judge didn't modify the restraining order anyway. It incorporated the visitation order and sent it back to the district court for further hearing. So there was no indication from the probate court that it conflicted. The other issue is that we offered to allow an exception that you sometimes see on these orders for limited visitation or limited contact with respect to visitation in case a problem did occur. And the judge refused to consider that, and that's the problem. This whole thing is problematic because the judge did not consider her safety at all. He didn't hear any evidence, so he could not have considered her safety when making this decision. The other issue that the judge considered in limiting both the time of the order and the relief to the plaintiff was the potential criminal consequences facing the defendant. Which we also believe is inappropriate, particularly in the light of the fact that he did not consider her safety.
Yeah, if I could ask about that. Take a case in which the defendant is charged criminally with a very serious crime, and the plaintiff is the accuser. Mm-hmm. What is a judge to do when he or she holds a hearing, and I understand you need to hold a hearing, when the defendant takes the fifth? What is the appropriate course of action for a judge in terms of giving or not giving meaning to the taking of the fifth?
Well, the judge has a couple of options in that case, and those, I think, are the facts that we were faced with here. What the judge that held a hearing, or declined to hold the hearing in February and April did, is said, I'm not going to make the defendant choose whether or not he needs to take the Fifth Amendment. And that is clear error. The defendant...
Your view is clearly they have to hold a hearing.
They have to hold a
And
hearing.
let's assume they hold a hearing, and the defendant's attorney says, Your Honor, he's facing serious criminal charges, he's going to invoke his rights under the Fifth.
And that's what happened at the July hearing in this case, when a hearing was finally held. And the problem with what happened at that hearing is the defendant said, I'm going to exercise my Fifth Amendment rights. We said, okay, under Frazado, we're entitled to an adverse inference. And the judge categorically said, no, I'm not going to give an adverse inference. The defendant is facing criminal charges, no. And that is
The judge didn't say, I have no power.
The judge did not say, I have no power.
He said, I'm not going to do it.
He said, categorically, I'm not going to.
Oh, categorically means what?
That means that what he said is that the defendant is facing criminal charges. I'm not going to issue an adverse inference.
All right,
That indicates.
but how is that? I mean, so are you saying he should have said, well, maybe I could, maybe I should, but I'm not? And then it wouldn't be categorical?
That's kind of what I'm saying. What I'm saying is that a district court judge has discretion whether to take the inference and not exercising that discretion, which is what the judge did here.
And he has to articulate to you that I am now exercising discretion, or?
For these reasons? Does he have to give you the reasons?
I don't know that he needs to give the reasons, but I think that it would be appropriate for the judge to say something like, under the facts of these cases, under the facts of this case, I find it's not appropriate or not necessary to take an inference. And this actually, the same type of thing happened again. I know this isn't before the court, but it happened again at the hearing we had last week. Ultimately, it was otherwise a fair hearing, but the judge, the minute counsel for Ms. Singh requested an opportunity to question the defendant, right away said, no, there's criminal charges pending. And I think, this court and the appeals court have indicated that in certain civil cases, an adverse inference may be appropriate. And if a judge is going to just...
But what you just said, that's different. It sounded like he was saying, no, you can't ask him to testify because he's going to take the Fifth. That's different than not taking an adverse inference.
That's right. That's more akin to what the judge did at the first hearing at the first hearings we had in February and in April. But what the judge did in July, I think, when you have discretion to do something and it categorically refused to do it, that's error. And it kind of, it raised the question.
So you're the judge. Yeah. How would you exercise discretion? What is the standard?
Well, I think that you have to weigh the circumstances. And,
what does that mean?
And well, I think you have to look at possibly how prejudicial it may be to the defendant. You have to look at the facts of each case. And I think the important thing to remember is this: whether or not the judge takes the inference, that's only one factor. If the judge chooses to take the inference, that's only one factor that goes into determining whether the order should be extended. I'm not suggesting by any means, I think there's a law that says this, that just because the defendant takes the inference, he loses.
What does the inference consist of?
It consists of a finding that because the defendant chooses not to testify, that should be taken against him negatively.
Yes, but meaning what? What's taken against him? What fact is the judge somehow allowed to draw from that?
I think you look at what the...
Here, what facts were you asking the judge to draw from taking the inference?
That I think it goes to suggesting that what the plaintiff had alleged and testified to were in fact the case.
But you don't disagree, right, that quite apart from the inference, since he has no other evidence, he's entitled to believe what she says anyway, right?
He is. I think that again, the inference is just one piece of the puzzle that the judge has to put together to decide whether to extend the order.
Okay, so basically you're saying a judge cannot say, I never make an inference in these cases, but it's okay to say, in fact, this particular case, I do not think it's appropriate to make an inference.
That's exactly what I'm suggesting, and the judge did not come close to doing that in this case. So I see that my time is almost up, so I just, to wrap things up, I'd like to make a couple points. The hearings in this case, particularly the February and most in particular the April hearing, were fundamentally unfair. As I said, it took 5 trips to the district court, all of which Ms. Singh had to face her abuser, which courts and the amicus brief in this case have recognized is a form of abuse, having to go in the court and face your abuser time and time again. That should not happen, and we're asking the court to adopt protections at hearings to ensure that that doesn't happen, and also reinforce the fact that the plaintiff's safety is the paramount and really the only factor that should be considered in determining both the duration of the order and the scope of relief that the plaintiff is afforded. And if there are no other questions, I'll rest on my brief.
Thank you.
Thank you, counsel.
All right. Hear ye, hear ye, hear ye. All persons having anything further to do before the Honorable, the Justices